Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition we have a special three-part series that deals with the major municipal court and criminal cases in the past year. This is part of the annual New Jersey State Bar Association and Institute for Continuing Legal Education program dealing with municipal court recent cases and recent court rules. And the first issue we're going to talk about is the Crawford decision. Now, I was running the prior summer, and one of my neighbors is a judge, and he goes, "Kenny, I got to talk about Crawford at an upcoming event. What is exactly the Crawford decision?" And I says, "Well, it's a major United States Supreme Court decision, Crawford versus Washington, 541 U.S. 36, decided in 2004, which bars most out-of-court statements and documents. So how has that affected us here in New Jersey? Well, back in 2006 in State versus Berezanski, the appellate division held that the defendant's right of confrontation was violated by the admitting of evidence of a lab report and required the chemist. So in DWI blood cases, the chemist is to be required. In 2007, State versus Renshaw, the appellate division held the nurse who withdrew blood can be required to testify in a DWI case, and that a certificate that it was taken in a medically acceptable manner is not admissible. And also the appellate division in 2007, State versus Kent, the defendant can contest the DWI blood lab reports as hearsay. So what's happened in the past year? Let's see. What about eyewitness statements to police at the scene? Well, oftentimes that depends. Let's say in State in the Interest of J.A., statements by eyewitnesses at the scene were not admissible as part of an emergency investigation. In J.A., the Supreme Court of New Jersey held hearsay statements were a narrative of past events and were made neither when anyone was in imminent danger. The statements were testimonial, and because the declarant was not produced as a witness or subject to cross-examination, the admission to the statements violated the Sixth Amendment. Therefore, the statements should not go in. On the other hand, what about statements of DYFS workers? And in State versus Buda, the Supreme Court of New Jersey held that the statements of a DYFS worker under emergency is admissible. The Supreme Court held the trial court did not abuse its discretion in determining that the child's statements to his mother and DYFS worker were properly admitted into evidence as excited utterances under New Jersey Rule of Evidence 803. So certain statements go in if there's an emergency, not. Well, what about breathalyzer certificates? There's no emergency there. Shouldn't they automatically be barred? There's no excitement there. They're not excited. The New Jersey Supreme Court in State versus Sweet held the Crawford Hearsay Rule does not apply to breathalyzer certificates. They said that the ambulance testing certificates and breath testing instrument inspection certificates are hearsay statements admissible under the business record exceptions of the Hearsay Rule. Those records are non-testimonial and thus are admissible. Now, what about the hearsay certificates of the Alcotest machine testing? Doesn't Crawford apply to those? The New Jersey Supreme Court in State versus Chun held that the new Alcotest breath testing machine results were admissible, but also the foundational documents evidencing the good working order of the machine shall be admitted into evidence in prosecutions based on the Alcotest reading. So the things are the most recent calibration report, control test, linearity test, and credentials of the coordinator. They held that these foundational documents are not testimonial as defined by the United States Supreme Court in Crawford. Such documents are business records and don't implicate the confrontation clause. Let's see. Now, occasionally, let's say you have clients that have more than one offense. And let me ask, who has a client as attorney who's ever gotten an independent blood test after DWI? Not too many. Let's say, and I recall a matter where a gentleman came in and he did have an independent blood test. And he says, wow, that was great. How did you know to do that? And he goes, oh, you told me in my last one, if I ever get another one, I should get an independent blood test. There's many examples of, oops, I did it again, where a defendant gets rearrested. So, in DWI post-conviction motions, where does one file the motion under Rule 7:10-2 for post-conviction relief? And in State versus Schadewald, the appellate division held post-conviction relief motion should be filed in the municipal court where the prior uncounseled conviction occurred.